Hello Goans, welcome to the show, this daily show called Bullseye, where I look at a particular subject or a matter that is really engaging Goans and deep dive and bring clarity to the clutter that surrounds that news. In the last 1 week or so, there has been a huge incident that has really taken the time, effort, energy of Goans, which was the disparaging and uncouth remarks made on our revered Saint Francis Xavier by one Gautam Khattar. Just prior to that, there was another controversy where Mr. Subhash Velinkar, the former chief of the RSS, called for Marathi to become the official language of Goa when the language issue is already settled and Konkani is the official language. In this episode, or the inaugural episode of Bullseye on In Goa, I'd like to go beyond that. Not necessarily on the statements themselves or the public reaction that took place. Today, I'd like to delve into the manner in which these cases are being investigated. And this is very important. Because whenever a remark of the nature of what Mr. Velingkar made, though Mr. Velingkar only called for Marathi as the official language, which drew a lot of outrage, or Khattar's remarks, for instance, the immediate reaction that happens in Goan society is, of course, anger, outrage, people taking to the streets, asking for the arrest of the people who have made those remarks. And the entire focus, and it becomes quickly very political as well. From a people's reaction, it becomes a political reaction. All opposition parties and other social activists jump into this, which again is not incorrect. That has place in society. But however, let us look at the pattern of these protests. See, what happens is that many of these people, or most of these people, look at the short-term goal of immediate arrest of the perpetrators. Correct. Beyond the arrest, what happens is after the arrest is made or not made, or in case suppose it is made or they are taken into custody, the entire effort to get justice, this whole "We Want Justice" campaign, seems to reach an end and a destination. So it almost seems that the arrest or the police lodging a case becomes the end of that protest or issue. And after the arrest is made, there is very little done later, and the case suddenly falls out of public memory as the investigations get prolonged, and then the accused get bail and they start lives all over again till still another issue comes up, and then people start chasing the next big issue. And there is a fear that might be happening both in Mr. Velinkar's case as well as in the Khattar case. Now, one is not passing any judgments here. The judgments will be done by the courts. I am essentially looking at the manner in which these investigations are being carried out, and if there is any public or enough public pressure to ensure that the investigations themselves are carried out honestly, robustly, quickly, and professionally, so that these particular cases lodged by the police or the investigation agency ultimately lead to conviction and not acquittal, or acquittal due to lack of quote-unquote evidence, acquittal due to lack of procedures being followed, and acquittal due to the case simply falling out of public attention. And that is exactly the loophole that many ruling dispensations take when they are interested in protecting these accused. And that is an area that I would like to point on and draw attention, both in the Velingkar case as well as in the Gautam Khattar case. Now, we all know what happened in the Gautam Khattar case. We know that his brother was first arrested, and of course he got bail. His brother Madhav Khattar was arrested. He got bail, and then Gautam Khattar was also taken into custody. He had chest pain, and he's of course, quote unquote, resting on a nice bed in the North Goa hospital, and not in a police cell, because he's not yet got judicial custody. So that is the state. Now let us look at how these investigations are proceeding, to give you a sense of how likely is Gautam Khattar going to be in trouble, and how likely is he going to be either convicted, or this case taking its logical conclusion and reaching a conclusion whereby he is punished for the kind of remarks that he's made. So ultimately that should be the main goal. The question is that the main goal? Okay. Now I will first look at how the arrest of his brother Madhav Khattar was made, which gives you an indication of how diluted this investigation could become because of what I'm going to point out now. Now, in the Madhav Khattar case, the defense, basically meaning Madhav Khattar's lawyers, they lent on 3 pillars, okay, to get him out on bail, which they ultimately got. They looked at Section 35 of the BNS. They looked at Aranesh Kumar versus State of Bihar. I'm just mentioning them. Those who are really interested can deep dive into it. And they looked at Satyendra Kumar Antil versus the CBI. But all these 3 cases are very important. The reason I'm mentioning these 3 cases is because it very specifically, all these cases, the judgment that came out of it is for offences punishable up to 7 years, which means less than 7 years. 7 years and less. Arrest is not automatic. It has to be justified, and justified not vaguely but specifically and in writing. If you don't do that, the case falls flat. Now look at the sections invoked against the brother of Gautam Khattar, Madhav Khattar. Okay, it was FIR number 44 by 2026, registered at the Vasco police station. Now, section 196 was put on him under the BNS 2023, which has a punishment of only up to 5 years and a fine. Section 299 was also levied on him, punishment of 3 years and fine, or both. So both these sections levied firmly fall under the 7 years category. No problem there, we are clear. Now the critical question that needs to be asked is, were summons issued and served in person to Madhav Khattar, brother of Gautam Khattar, or not? Because under section 35 of the BNS, this process of arrest cannot just be symbolic. It has to be, the compliance has to be very, very clear. And that is important, because the misuse of arrest powers in low punishment offences is something that the court takes very seriously. So hence, if the Vasco police is serious, or was serious about ensuring that this case reaches its conclusion and they getting success, meaning conviction of this guy, they should have ensured that procedural compliance was very, very thorough. And my argument here is that that was not the case. Because what happens is, despite offences carrying a maximum punishment of about 5 years, this arrest was executed. Now, was it executed just because of public pressure? Was it executed just to show that they are on the right track and they will get the brother somehow? Because if you make a wrong move and the arrest itself of the brother is questioned, then the motive in the eyes of the law in pursuing a serious investigation in the eyes of the law gets doubted. And that is what may happening here. Now, suppose they say that he did not receive the notice, or he did not receive the summons. That itself is not a ground for arrest, by the way. The law requires something more. It requires that there must be a clear-cut mention in writing on the causes of the arrest. And it has to be very clear, very detailed, very purposeful. And an application of mind has to be mentioned, not mentioned, evident in the police investigation. Because just a mechanical satisfaction of the arrest conditions is not enough. So here the police must record why the arrest is necessary. Did they record it in Madhav Khattar case? No. Did they record why there was a risk of flight? Did they record why evidence was maybe tampered with? Did they record why he may influence witnesses? This needs to be not just cursory and broad. The court wants specific details with some amount of evidence that can be proven. Now, if that does not happen, that falls short of the Aranesh Kumar judgment. Okay, so defective communication on the grounds of arrest is seen very seriously by the court, and the arrest is declared as null and void or not good according to the law under the Aranesh Kumar standards. That's very important. There were also two other rulings that I would like to refer to, which the Vasco police will have a challenge because if they fall short of the mandatory provisions in those two cases. One is Pankaj Bansal versus Union of India. Second is Prabir Purakayastha versus State of NCT of Delhi. These two cases clarify that the grounds of arrest must be meaningful, specific, and communicated in writing. Here, the allegations in this Madhav Khattar case is that the grounds that were provided were generic and formalic and not necessarily specific. The court also makes another subtle but very important observation. No objection was raised at the first remand stage of he either absconding or refusing to accept the notice. And this is important. So the courts are very clear that it is not enough to say that you are arrested for this offense. The ground must be detailed to allow the accused to challenge the grounds of arrest effectively. So this is a very deep procedural insight that these judgments have come, and which will be not only challenged, but that was one of the reasons why the brother actually got bail, because the procedures did not meet the guidelines of the cases I've just referred to. Now what happens is the courts are very clear that under public pressure, what you do is you carry out a public-driven, perception-driven arrest. You do not justify court-driven and procedure-driven arrest, and that is where the problem is. So, the arrest may be legally justified, but if it is not shown to be convincing, then the courts will come down upon you. And that is where the issue is. Because ultimately, arrest is not necessarily punishment. Arrest is just a tool to secure investigation. And then what happens is, when people get either anticipatory bail or bail in Madhav Khattar's case, which has already happened, then the momentum falls. And the momentum will also fall in his brother's case, because the same kind of procedural, I would, if not lapses, but lack of attention is also witnessed more or less in the brother's case as well, who has now applied for bail and will come up for hearing. Because what happens is, then the momentum fades. The moment you start getting bail, the momentum fades, because arrest has happened. Once the bail happens, then even the public outcry is not as loud as initially when the arrest is demanded for. Public attention shifts, momentum fades. Then the case disappears into the system, into what is called the cold storage, and the cold storage is never opened for years and years and years unless there is a political reason to at some later stage. Because do understand that it is once the procedural rules, regulations, court judgments are followed, then it is not very difficult to crack these cases, because these are literally open and shut cases. Whether he made a statement against Francis Xavier or not, and he made it at a public venue, it is very clear what he said. So you don't need a deep DNA analysis, you don't need handwriting experts, you don't need anything of that sort. You have video footage, you have eyewitnesses, both official and unofficial. So you don't need to be a Sherlock Holmes to crack cases like this. Therefore, if you do these procedural lapses, or if you do not pay attention to the manner in which these arrests have to be carried out, then the doubt that creeps in, that is this deliberately done to dilute the case, to enable these accused to ultimately get bail. And that is where the problem lies. Are these procedural lapses or this lack of grounds for arrest and whatever else I've said earlier, if these are not done by the police and if they are not done deliberately, then the question that arises is that is the police and the system aiding and abetting the release and the freedom of people who have been accused of grave crimes and against whom the public of Goa and elsewhere, of course, want justice? That is the big question. Because all you need to do here is that if your procedures for arrest are done properly, you need to seize all the video footage, you need to talk to the eyewitnesses, you record the statements of all the eyewitnesses under section 183 of the BNS. You then file the final report under section 1, you record the statements, you record the statements under 183 of the BNS, and then you file a final report under section 193 of the BNS. And realistically, this can be completed even within a week. And a charge sheet can be filed very, very promptly. Trial could begin without delay, and the matter could reach a conclusion in less than a year. We doubt whether that's going to happen. We seriously doubt. What we are seeing is this so-called wishy-washy manner of the arrest and the investigation. The investigation continues indefinitely. What is there to investigate in these cases? As I've just mentioned. So it gets investigated when there's really no rocket science in this. Time passes, public memory fades, and eventually a closure report may be filed on the ground that no evidence was found, and the matter completely gets dead and buried. R.I.P. Rest in peace. And that is the real danger. That a case collapses due to poor investigation, it is often projected that it lacked merit, and so on and so forth. Now, the point being that the same thing can happen with Madhav Khattar. With Gautam Khattar, the brother. Because as far as Gautam Khattar is concerned, the cases filed against him are also section 196 of the BNS and section 296 of the BNS. 196 has a punishment up to 5 years, 299 has a punishment up to 3 years. So the same things that were spoken about as far as the brother was concerned, the same questions arise during the procedure for Gautam Khattar, the prime accused. Were the summons served in person or not served in person? Arrest orders the warrant was secured from the court, but were the summons served in person? That is important. So the idea here is that this is extremely important, because the defense here again will invoke Aranesh Kumar and Satyendra Anil cases to say that arrests must be necessary and not routine. And since it carries an offense of less than 5 years, was the arrest executed after due procedure? And police non-cooperation is not, the police argument about non-cooperation is not really something that is accepted by the courts. So this is where the matter lies, that this wishy-washy lack of procedure has this basic problem, and this falls short, again I repeat, of Pankaj Bansal versus Union of India. It falls short of Prabir Purokayastha versus State of NCT and Delhi. These are important judgments. Do deep dive into this and read, because these are critical to your understanding of how these legal cases really must be handled. The same logic exists for even Subhash Velinkar. Now, Subhash Velinkar case, the same issue that is there, because he got anticipatory bail. All one needed was to get the video footage of his statement when he asked for Marathi as an official language, get the witnesses to come and testify, because that's extremely important. The witnesses will have to testify in court. Just record statements which the police will not do. And very clearly, once those statements are recorded, you file a charge sheet. As I mentioned before, once you file a charge sheet, you start the trial. And I'm not saying whichever way the trial goes. If the trial ultimately concludes that Subhash Velinkar is not guilty, you set him free. But here the thing is, it'll drag on and on and on. The charge sheet will not be filed. the trial will not start, and the case will ultimately be forgotten and die a natural death. We are not talking about whether Subhash Velinkar is guilty or not, whether Gautam Khattar is guilty or not, whether Madhav Khattar is guilty or not. That is for the courts to decide. But it is very important that you prepare yourself. The investigation must prepare themselves to ensure that they have enough grounds for conviction in cases where conviction is easier to get when detailed investigation and forensics are not required, and that is the issue. So the broader point that I'd like to make in the Velinkar case is that video footage exists, eyewitnesses are identifiable, and all you need to do is you seize video footage, identify the eyewitnesses, review footage to map the presence, record statements under 183, and then file a final report under 193 BNS. That's all that you need to do. Before we conclude, let me point out this, that all we need here is, because if cases collapse under these kind of situations, then your due process of justice, which ultimately leads to guilt or innocence, completely falls. And more importantly, politicians or people associated with politics who actually make these remarks to ensure that there is a counter reaction and keeping these issues alive to their benefit, they are the ones who stand to benefit. A Gautam Khattar, when he knows that he can get away after a few days of arrest and hospital and chest pain and so on and so forth, not only him, but others who intend to make these kind of remarks, statements, or carry out these activities will get further confidence that they can do all this, create a political unrest or a communal unrest, and then spend a few days in custody and then be a free person with the case dragging on and ultimately forgotten. And this is something that we need to take very seriously. We must make the police accountable, not just to arrest, but ensure conviction, and make the governments also accountable for the kind of policing that they run. Thank you very much.